Good morning. I'm Gary DeWaal, and this is Bridging the Week for June 20th to 24th, and today is June 27th, 2016. The United Kingdom's vote to leave the European Union roiled worldwide financial markets on Friday and will dominate financial headlines for quite some time. On a less macro basis, a broker-dealer agreed to pay sanctions of $415 million for not complying with the customer protection rule of the Securities and Exchange Commission, while the SEC sued a UK citizen for hacking into the brokerage accounts of investors to trade on an unauthorized basis in order to benefit separate trading in his own personal account. Meanwhile, the CME Group brought disciplinary actions based on violation of its rules related to block trades, exchange-related position transactions, and wash sales. Because of the upcoming Independence Day holiday in the United States, this is my last Bridging the Week video until July 11th, so I can get on vacation. Let's get started. Two Merrill Lynch entities agreed to pay sanctions of $415 million to resolve charges brought by the Securities and Exchange Commission that, contrary to SEC requirements, they failed to set aside sufficient funds for the benefit of their customers from 2009 through 2012 in its so-called reserve account and failed to hold fully paid for securities of their customers in certain approved locations in lien-free accounts from 2009 through the present year. The SEC's requirements are encapsulated in its so-called customer protection rule. According to the SEC, during the relevant time, Merrill Lynch engaged in certain transactions with customers known as leverage conversion trades to finance certain of its own business transactions. The SEC said the companies accomplished this by including margin loans to its customers as part of these trades, which had the effect of reducing the amount of cash and securities Merrill Lynch itself had to maintain in its customer reserve account. Merrill Lynch used this freed up cash to finance inventory that was used in the trades, alleged the SEC. In addition, the SEC charged that, during the relevant time, one of the Merrill Lynch companies held a substantial amount of fully paid for and excess margin customer securities in clearing banks or other approved depositories subject to liens, contrary to the SEC rule, which requires no liens. To resolve the SEC's allegations, Merrill Lynch agreed to pay a fine of $358 million, disgorgement of $50 million, and $7 million in interest. Separately, the SEC commenced enforcement action against William Terrell, the head of regulatory reporting and financial and operation principles for one of the two Merrill Lynch companies during the relevant time, where he oversaw the regulatory reporting for both of the companies. The SEC charged that Mr. Terrell willfully aided and abetted Merrill Lynch's overall violations. This action is pending. Simultaneous with disclosing its actions against Merrill Lynch and Mr. Terrell, the SEC announced a Customer Protection Rule initiative to encourage broker-dealers to review their handling of customer funds and securities and to self-report to it by November 1st, 2016, any potential violation in order to receive favorable settlement terms in a potential enforcement action. At the same time it encouraged broker-dealer firms to self-report, the SEC announced it is embarking on a risk-based sweep of broker-dealers to assess their compliance with the Customer Protection Rule. I guess this is the proverbial carrot and stick. The SEC filed charges against Idris Mustafa, a UK citizen, in a federal court in New York, claiming that Mr. Mustafa hacked brokerage accounts of unwitting U.S. investors to facilitate his own trading activities. According to the SEC, during at least April and May this year, Mr. Mustafa impermissibly accessed the accounts of investors at both unnamed U.S. and non-U.S. brokers and placed unauthorized trades of publicly traded corporations. Either just before or just afterwards, he placed trades in the same securities in his own personal account in order to profit from trading in the hacked accounts. The SEC seeks injunctive relief, disgorgement, and civil penalties against Mr. Mustafa. The successor to New Edge USA LLC agreed to pay a fine of $100,000 and disgorgement of an excess of $19,000 to the CME Group to resolve charges that New Edge allegedly pre-hedged potential block trades on 6 days from November 2013 through January 2014, contrary to Chicago Board of Trade rules. According to the CME Group, on the relevant occasions, traders acting for the firm received solicitations to engage in block trades on CBOT products. However, prior to executing the transactions for the customer, the traders entered into separate block trades with a liquidity provider to hedge the firm's potential exposure, said CME Group. Separately, the Linen Group agreed to pay a fine of $70,000 for, on 2 days, simultaneously placing orders to sell and buy the same expiring cattle futures contract for a customer. According to CME Group, the purpose of these purported wash trades was to freshen the customer's long position in order to delay delivery. Additionally, Credit Suisse International agreed to pay a fine of $15,000 for engaging in one exchange-related position transaction that purportedly entailed a contemporaneous offset of the related position. The CME Group claimed this transaction was an impermissible transitory EFRP and non-bona fide. Last week, the board of Nasdaq Oslo ASA published a letter of warning against J. Aron & Company for the placement of an unintentional sell instead of buy order by one of its traders in the exchange's order book of an electricity futures contract. The board claimed that this error constituted market manipulation under its rules. According to the exchange, the trader's sell order, which it conceded was inadvertently entered, had the impact of lowering the best asking price for the relevant futures contract. In its warning letter to J. Aron, Nasdaq Oslo relied on its rule prohibiting market manipulation, claiming that this sell order, quote, gave or was likely to give false or misleading signals as the supply for and price of a listed product, end of quote. This seems like an unexpectedly low bar and contrary to the traditional standard of manipulation that there be a finding of intent or even a finding of intent or recklessness to show a manipulative device, scheme, or artifice to defraud. And finally, on June 23rd, a majority of voting residents of the United Kingdom voted that they wanted the UK to cease being a member of the European Union. It appears that the current UK Prime Minister, David Cameron, will step down from his position by end of October and leave the formal notification of the UK's intended withdrawal from the EU to his successor. Following this notification, the UK and the EU will have 2 years to negotiate terms of the withdrawal and the UK's and EU's subsequent ongoing relationship. The London office of Katten Muchin Rosenman has prepared an excellent summary of the implications of this historic event, now published on the Katten website. Check it out. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out, too. I'm Gary DeWaal. Have a great 2 weeks, and ciao.